Good morning. My name is Justin O'Brien of Dwyer & Calora. For the plaintiffs, with me is Michael Calora. May it please the Court, the plaintiffs in this case are a class of former employees in Massachusetts of defendants Citigroup and related companies who forfeited earned compensation to the companies under the company's capital accumulation plan, or CAP.
Were they getting dividends on the stock while it was held in this CAP plan?
They were getting dividends on the restricted stock during the vesting period, Your Honor.
This plan was voluntary, wasn't it, at least for the ordinary employees?
I'd say two things, Your Honor. First, there was a component of the plan that was voluntary in the sense that the employees enrolling in the plan signed a form. There's evidence in the record that there was significant pressure on those employees to participate, first of all. And secondly, the information provided to the employees regarding the ultimate effect of the plan we submit was entirely inadequate, in that there was only really one line, or I should say part of one line, in all of the information that they received that indicated that the forfeiture provision would apply.
But what's that got to do? I mean, this is a deferred compensation plan that employees have signed up for. Haven't we ruled that deferred compensation plans are not covered by the wage statute?
Your Honor, I'd submit that the plan here was drastically different from the plan that was at issue in the Boston police case. This really was not your typical 401k type retirement plan where compensation is deferred for years and years and years and vests on retirement.
How long? That's one thing I never understood. Maybe I'm missing it. How long was it before the stock would vest?
Depending on the particular plan that was at issue, it was either 2 or 3 years.
For the payroll deduction, is it payroll deduction folks, the sort of voluntary folks, regular folks, that would be 2 years?
That would be 2 years, Your Honor.
So if you left in that 2-year period, you forfeited not only the potential stock you were going to get, but also the money from your salary that would have bought it.
That's exactly right, Your Honor.
And ditto for the 3-year thing.
That's the same. There's a different compensation that's at issue in the so-called 3-year thing.
Well, with respect to the 3-year thing, I mean, those are clearly bonuses. I mean, our wage statute doesn't cover bonuses of that sort, does it?
Well, Your Honor, would submit that it should, in that for several reasons. One, the bonuses that you're talking about are, in this case, are not some sort of illusory bonus that's going to be available at the end of 3 years if you're still at the company. This is a bonus that was awarded year by year, in the sense of you got to the end of the year as an employee, and the company said, congratulations, you got X as a bonus.
And your bonus will be in part paid in cash and in part paid in this deferred compensation plan in which you can earn significant benefits, but if you leave, you're going to forfeit that part of your bonus. What's wrong with that? Why is that a violation of the wage law?
Because, Your Honor, we believe that the public policy that's at issue is the same as it would be for commissions, in that, or other types of compensation, in that once the bonus is awarded, the employee is staying there under the impression that they have some entitlement to that bonus. The other thing I'd point out is...
How could they have entitlement if the bonus is contingent on them staying for a certain period of time? How can they say, well, we're entitled to it today, even though we actually don't get it unless we stay 3 years? How?
When I say entitled, Your Honor, what I mean is that the employee is going, once the bonus is held out, in the sense of if you're still here in 3 years, you get the bonus. The employee's already done whatever they have to do to get the amount of the bonus determined.
No, they've earned the right to get a deferred compensation component. That's part of their bonus. That's what they've earned, right? They haven't earned the right to get that money today because that's not the bonus plan.
Yes, Your Honor, but if the bonus, if the capital accumulation plan, if the forfeiture violates the wage statute, then...
Mr. O'Brien, it's sort of the cart before the horse. Presumably an employer can say, I have X amount of cash and I'm going to pay workers for this. I'm also going to reward people who I would like to make sure stay with the company. But I'm only going to reward them if they stay with the company. In other words, past behavior is predictive of future behavior. You haven't done the future behavior, but I'm going to make a guesstimate that if you stay, you will do well. And so I'm going to give you, it's really not it's not a bonus in that sense. It's simply saying, I'm going to reward you if you stay, because based on your behavior this past year, I've determined that it will be very valuable if you stay.
Your Honor, I'd say two things. First of all, I think it's important to distinguish when we talk about bonuses that there are really two different programs at issue.
The bonus program and the branch manager.
Exactly.
Yeah.
And the branch manager program the bonus was determined according to a formula which was really based on performance for the year. And there's testimony in the record that employees, the branch managers, could look at the formula, look at the performance of the branch and monitor how they were doing, such that when they got to the end of the year, they'd say, I'm going to get this amount in a bonus.
So it was
So I think-
calculated? In other words, is it like a commission? I didn't get that sense.
It's calculated, but isn't that in a law? I mean, this may be, but in a law firm, you may say, people, associates who bill 28 billable hours.
2,800?
2,800.
was
Thank you.
gonna
I'm so familiar with it. I just assumed 2,800 billable hours. Two things. A, we're going to have a part of. There's going to be a formula so that you know and your colleague knows that if you bill 2,800, what it'll be. So you can decide whether you want to lead a miserable life and put in 2,800 billable hours. But part of that is going to be compensation for that year. But part of it is because the law firm is saying these are the kinds of people we want to remain. But we're not going to pay them cash. We're not agreeing to pay them cash unless they remain. What's wrong with that? And why is that a violation of the wage statute?
Because, again, Your Honor, I think it's that the bonus, if you will, vests to some extent in the employee at the end of the year. The company is taking deductions prospectively throughout the year based on what it anticipates from all of the employees' compensation, from the total compensation.
Well, that's the first plan.
It's the second plan as well, Your Honor. It's both the bonus program and the branch manager program that they're taking based on a total percentage of our percentage of the total compensation throughout the year, based on what the bonus is anticipated to be.
Explain that. I read that in your brief, and trust me, I was confused.
Well, Your Honor, the way I understand it is that
I'm a branch man, or I'm covered by the bonus part of this program. So give me some hypotheticals about me.
basically, if your total compensation amounts to X, then you fall in a particular category, and during the course of the year, it's sort of anticipated that you're going to have a certain percentage, a bonus of a certain amount.
Over X, that'll be X plus?
X plus bonus?
Well, X plus bonus is the total compensation package for the year.
So I have the
anticipated bonus.
compensation X. It's anticipated that I will get bonus Y. So X plus Y is my total compensation estimated.
Right. And there's a deduction made based on that estimation at the end of the year when the bonus is
You mean
actually
tax
calculated.
withholding? Is that what you mean?
I'm sorry?
What's the deduction?
It's the deduction for the purposes of the CAP plan. That's the
As
money
the year
that's-
is going on?
Yes.
Yes.
From
It's-
all employees.
I'm sorry.
From all employees.
From all employees in the plan.
In
Yes,
the bonus
correct.
plan.
I'm sorry, but I don't understand something very basic, and it's my failing. But if you win, and this bonus or whatever is subject to the Wage Act, and the employers don't like that, then they'll just take away the bonuses. So how do you, in the overall scheme of things, win?
Your Honor,
Your
and
clients win the future.
But I mean, other people won't win. And assuming your clients go on to work for this or similar type companies, and I assume this type of practice is quite prevalent in the industry, how do people in your client's position win overall?
well, it's a win in the sense of
It's a win for
true-
these few people who are here.
Well, Your Honor, it's also a win in the sense of truth in advertising, in that, here's what your compensation is going to be for the year at this company. including this
Yeah, but these
anticipated
bonuses are tremendous. I mean, and so if they get taken away, what,
Well, Your Honor, I should point out that the cap plan was available to at least certain employees who had much smaller bonuses. It wasn't simply sort of the highest paid executives at the company.
Well, the highest paid executives had to participate because this was part of their bonus plan, but the lower paid employees could participate voluntarily. You say it's, well, maybe didn't have full information, by having money deducted for purposes of the plan.
That's right, Your Honor.
But for the 3-year plan, what's wrong with the company trying to entice its employees to stay? There's a benefit to the company.
There's nothing per se wrong with that. It's how the company chooses to go about it. It's one thing to say, if you're here at the end of 3 years, we're going to give you a bonus of X. It's another thing to say, and I recognize this is a somewhat of a fine line, but to say that you get to the end of the year, here's your bonus, here's some of it in cash, but actually we're going to withhold part of it, and if you're not in here in 2 or I should say 3 years, you're not going to get any of the bonus.
So
What's
it's just how
wrong
it
with
gets,
that?
it's how it gets worded, I take it. I mean, maybe this is what the Chief Justice was asking, but they could, you would not disagree that they could say, here's your bonus, which is, let's say the total amount of the bonus is 100. And so they say at the end of the year, here's your bonus for this year, it's 75, and if you're here 2 years from now, you're going to get another 25. That wouldn't be a problem, would it?
No, I don't believe it would.
But isn't that, in effect, what they've done?
Again, it's not what they've done, particularly with the branch manager program, where there's a performance-driven formula by which the bonus is calculated, so that they get to the end of the year and they think, well, this is my bonus, and then the company, as they do with the commission plan people, they say, you know, we're not actually going to give you the whole bonus.
But that's not a surprise. I mean, it's not like at the end of the year, oh, guess what, you're not really going to get cash bonus. I mean, this is part of the plan. This is what they buy into. This is part of their, isn't it? The company doesn't decide at the end of the year, oh, guess what, we're not going to give you your estimated bonus in cash. We're going to do a little bit this and a little bit that.
No, it's just
The
that
policy,
aspect of
that's the compensation policy of the company, right?
Right.
If we were to agree with you, would that mean that the bonus had to be paid within 6 days of each of the weeks, or in other words, I mean, essentially, as I read Section 148, if you've got wages due, you have to pay them. If they've been earned, you can do it weekly or bi-weekly or on some other basis. Does that mean that the bonus has to be paid out as you're going along?
I don't believe it does, Your Honor. I believe
And how do you get around that?
because there's a case, the name's escaping me at the
Yeah.
moment, but there has been case law that despite the sort of title and basic provisions of the weekly wage law, so-called, there's no requirement that that wages actually be paid on a weekly basis. And I think particularly where the court has read into the purpose of this statute a prohibition on unreasonable detention. There's a difference between sort of reasonable detention of wages for purposes of a bonus plan where you're going to be getting the bonus at some point, and an unreasonable detention, which is the complete forfeiture of either that bonus or commission or any other form of compensation.
So what you're saying is, if these employees had stayed for the 2 or 3 years, you wouldn't be arguing that they needed to be paid before the 2 or 3 year point when, under the cap plan, they would be paid. Your argument is, if they leave within that vesting period, that's where you are saying that's the problem.
That's correct, Your Honor. Our argument is entirely tied to that clause of the statute that says all the provisions about timeliness of weekly wage payment or payment on a certain basis. But when the employee leaves, the employee shall be paid in full. It's granted it's in a sentence or in a portion of the statute that's referring to wages, but that clause just says paid in full on termination.
How do you deal, I saw how you dealt with it in your brief, but the Citigroup takes the position that, look, the whole tax basis of this plan requires in fact, that there be a substantial loss of risk, or a substantial risk of loss, or a substantial risk of forfeiture. I can't remember what the words are. And
Forfeiture. Yeah.
forfeiture. And that's exactly what this plan provides. If it didn't provide that, it wouldn't be tax exempt, or it wouldn't conform to the tax laws. Couldn't be done.
Your Honor, I'd suggest, as we do in the briefs, that there's really no basis for that argument. It's true that that is one way to achieve the tax deferral that the CAP plan achieves, but under Section 83, which provides for substantial risk of forfeiture, the statute says as well that if you're simply making an unfunded, unsecured promise to transfer a benefit at some point in the future, then there is no need for substantial risk of forfeiture. And I should point out that the plan here provided for deferred stock, so-called, as opposed to restricted stock, which the company could have issued at its discretion and which would have met that criteria, such that there would...
Well, you're saying the company could have set up another, different kind of plan.
It could have exercised
another tax provision.
it could have exercised the discretion that it had under the plan as set up to issue deferred stock instead of restricted stock, and there wouldn't even be the suggestion
But of course, restricted stock is a benefit because I take it during this period of restriction, your clients got dividends and voting rights.
they did. Under the deferred stock, they would get
Same
dividend
thing?
equivalents, not dividends specifically, but there
Thank
would
you,
be.
Mr. O'Brien.
Thank you.
Ms. Bansal?
Thank you, Madam Chief Justice. With the court's permission, we have an application for my admission pro hoc vice.
Which we will allow.
Thank you. The question certified to this court by the Federal District Court of Massachusetts is whether the Citigroup CAP plan, the Capital Accumulation Plan, violates the weekly wage law. Most certainly it does not. But before I get into the legal argument, I think it's important to go through the separate plans and the specific provisions of them that constitute the CAP plan. There are 3 programs within the CAP plan.
Right.
The first is what we have referred in our brief as the Financial Consultant Plan, which is an elective program, and it covers the vast majority of Citigroup's financial professionals. They're allowed at their election to choose to receive some portion of their stock in a portion that they designate in the form of restricted stock.
Portion of their compensation?
Yes, a portion of their compensation in the form of restricted stock. So they agree that some portion of that compensation will be earned and become vested 2 years down the road. And we submit that that does not constitute clearly under this court's precedence wages under the weekly wage law. So that's one program. That's the Financial Consultant Program, and it's an elective program. The forms that are signed are quite clear in terms of the elections that employees make that choose to participate in this program. There's an election form that says that a percentage of compensation will be received, quote, in the form of restricted stock, and that if the employee leaves the company voluntarily or for cause before the restricted stock vests, which in this particular program is a 2-year vesting period, then, quote, I will forfeit the restricted stock as well as the compensation I have authorized to be paid in the form of such restricted stock.
So
End
you're
quote.
saying it's basically, this is the kind of situation where you have something that is contingent on an event occurring, and if you don't wait until the event occurs, it's not wages for purposes of the wage statute.
That's correct. As this court said in the Boston Police case, not all compensation is wages. And here, the employee elects to receive some of his or her compensation in the form of unvested stock, which we submit as not wages under Boston.
Assuming that I, as an employee, elect to participate in the financial consultant program, and let's assume my weekly wage is $100, and I elect to participate, do I get $20 of payment a week and then $20 of deferred stock? Of stock?
You mean 80 and 20?
I mean, yes, 80 and 20.
I think the way to view it is that you get $80. It's a little complicated because the formula, part of the benefit that Citigroup offers its employees is they're able to purchase the stock at a discount. So the $20
I see.
of stock would actually be 1/3 more of that. So,
So in fact, you're getting a quote, additional compensation in addition to the benefits of deferral.
That's correct. And in addition, of that $20 compensation which you elect to receive in the form of restricted stock, you also get to defer the taxes on that.
Well,
So you-
no, I understand that. It's an
Right.
enormous benefit.
Right. So you get the tax deferral plus you get the discount.
Do you get an internal build-up as well? Yes. In other words, if the stock price increases, forget it. It's okay.
It's
Yeah,
not
I mean-
it's not really accurate to call it deferred compensation, is it? In the sense of the Boston police case? Because the Boston police case had no forfeiture at issue.
Well, two responses to that, Your Honor. First of all, I think it's unvested compensation. It's contingent compensation in the same way that the deferred compensation plan was in Boston Police. So when an employee receives compensation in the form of restricted stock, that restricted stock, because it's subject to future performance, future continued employment at the company for 2 years, it's subject to a condition in the future. That is not considered wages under Boston Police. With respect to the
Well, I'm not so sure about that, because under Boston Police, they're talking about a traditional deferred compensation plan, are they not?
yes,
Yeah,
I think that's right.
in the deferred compensation plan, you get your money back if you leave employment. You might not get as much if you've invested it unwisely in, various kinds of funds, but you get it back. Here you don't.
There's
So that seems to me to totally eliminate the Boston Police case from any persuasive value for your position in this case.
Well, the issue, with all due respect, Your Honor, in Boston Police was not about forfeiture or whether or not that's permissible. It's whether or not the form of compensation constitutes wages under the weekly wage law. And just to pick up where the bench was asking my colleague at the end of his argument, in this particular case, it's notable that the plaintiffs are not saying that the deferred compensation or the restricted stock is something they should have the right to receive within a week or a month, or wages that the weekly wage law says should be paid regularly. The purpose of the weekly wage law is to prevent the accumulation or the withholding of wages over an undue period of time. They're not saying that holding this for 2 years is disallowed. So their concern is not really with the issue that's at the heart of the weekly wage law. And the issue in Boston Police had to do with the fact that the particular deferred compensation was not being purchased. It wasn't being sent to the deferred compensation investor, so to speak, within a sufficient amount of time. So at issue in that case was the heart of what the weekly wage law is about, which is making sure that
You get paid on time.
you get paid on time. That's right. So the issue in Boston Police was not about forfeiture, and I think forfeiture is a little bit of a red herring here. And in fact, there's numerous cases in this court under the weekly wage law, as well as under common law, which says that forfeiture is not impermissible under the weekly wage law. For example, a number of the cases that we cited, including Scharf, Buell, Sterling Research, and Hoops, all of these involved situations under the Wage Act where an employee was contractually entitled to certain payments, compensation, bonuses, different forms of payment, different forms of compensation, but the condition for he or she receiving that compensation was that they continue in the employ of the company. When they didn't continue in the employ of the company, they forfeited that compensation. And the courts in those respective cases found that there was not a violation of the Weekly Wage Act because the condition precedent to the vesting of that compensation had not yet occurred. So we submit that's precisely what's the situation we have here. And also on point is this court's case, Harrison, from 2001. Now, that was not a case under the weekly wage law, but it's remarkably on point because in that particular case, the employee said that he gave up getting a certain amount of salary that he would have otherwise earned because he agreed to receive part of his compensation in the form of company stock that would vest on a specified schedule in the future. Now, in that particular case, he left, his employment was terminated, and a bunch of that stock hadn't, in fact, vested. And he argued that that stock was earned by him because it represented the work he had done in the past, and it represented payment for past services. Now, this court said that that was not, in fact, earned compensation. because even though he would have otherwise taken a higher salary instead of taking those unvested shares, the terms of the agreement that he had meant that those shares would not vest until some point in the future. So under those, even though that represented compensation for services he had already rendered, the court held that that was not, that those were not wages.
Ms. Spencer, may I ask you this, and you may have answered it in your brief, and I just canceled the call. You cite us to a number of cases, and they're mostly intermediate appellate cases, I think, around the country, where these kinds of deferred comp plans have been, where the court has determined that they do satisfy the applicable state wage statute.
Right.
Are those?
Are you talking about the cap, the
Yes.
specific cap plans?
Yeah.
Cap.
Are they cases that go the other way?
There are not. There are not. There were in Illinois and New Jersey. The intermediate appellate courts
I know about that.
had
yeah.
gone the other way, but then they were reversed.
Right.
So no, to date there has not been a single court that has invalidated cap under any state law or even under common law.
So you've talked about the financial consultant
Right.
program. What about the
Right. So the
bonus?
financial consultant program is the elective program. The second program is the bonus program.
Right.
Now, the bonus program is 100% entirely discretionary as to whether or not a particular employee even receives a bonus in a given year. Now, Chief Justice Marshall asked the question, made the analogy with respect to the law firm. An associate bills 2,800 hours. Isn't he or she, there may be some basis on which that bonus is allocated or distributed. But in this particular case, I think the more apt analogy is that the 2,800-hour guideline would be a guideline, but not a guarantee of a bonus. In this particular case, Citigroup says...
Yes, no, I was talking about, mine was to the branch manager case, not the bonus qua
Okay,
bonus.
well, okay, I'll turn to that.
So bonus is entirely discretionary.
It's entirely discretionary. So if Citigroup, has a bad year, if it has a particularly good year, the range of it could go from anywhere from zero to a very vast sum.
Is it the case, as was argued, that at the end of the year, if you're the person with the bonus, you are told your bonus is going to be X amount? Is that so?
But there's no guarantee of that at the beginning of the year,
No, I know. But
Yeah.
when you get to the end of the year,
right?
and the company says you have a $1,000 bonus, and I take it under this plan, you'll get some portion of it in cash, yes?
That's right.
And some portion of it in deferred
That's right.
stock.
Restricted
So
stock.
if you leave, if that's December 31, and you leave on January 10th of the following year, all you're going to get is that portion of the cash. You've lost the deferred.
That's right.
So at the end of that year, it isn't I mean, in the sense that it's a defined amount of money, but you're just saying it's sort of like the financial consultant. There has been an agreement, well, I don't know, is it like the financial consultant?
Well-
That part of it is going to, that part of the plan is this bonus, this is Justice Cordy's point before, that part of the plan is that the bonus is made up of two components, one you get now, one you get later, and that's just the way it is?
Right. It might be a defined amount of money, but it's not due and payable,
Yeah.
which is the point under the weekly wage law. It's not because it becomes payable 2 years down the road or 3 years down the road in case of the bonus program. So that's why the bonus program is not.
Well, is it even a defined amount of money because it's a number, or is it a number of shares of stock because 2 or 3 years later the stock will be worth different?
That's right.
So it's not
yeah.
even a defined
Yeah.
amount.
I guess
of
I'm
money.
saying even if it were a defined amount of money, it's certainly not due and payable because it's due to this future contingent vesting. The third program, so the bonus program is entirely discretionary. Under this court's clear case law, bonuses that are entirely discretionary just do not constitute wages. And the plaintiffs have not cited a single case in which they can say that discretionary bonuses are wages. The third program is the branch manager program, and this affects just a very, very small number of Citigroup employees. The branch manager program is, in fact, a hybrid of the payroll program, the financial consultant program, rather, and the bonus program. And what it says, essentially, is that branch managers, they will get a portion of their they'll get a certain amount of compensation that may or may that are probably wages, and then on top of that they get a bonus, and the bonus, some portion of that will, it's like the bonus program. It will either come in the form of deferred or restricted stock, Or, for some of the branch managers, they have the opportunity to elect to participate in the financial consultants program. So the branch manager program is really a hybrid of the two other programs. It's not really unique. The only difference is that the bonus portion of the branch manager program does have certain guidelines that give some guidance as to how the bonus might be calculated. Unlike the bonus program, which is entirely discretionary and has no guidelines, the branch manager program does have some guidelines.
Written guidelines.
Yes, it does have some written guidelines. But again, the same written guidelines continue to say that it's entirely discretionary. It depends on any particular year. So even though they're kind of general guides, there's no proportion, there's no allocation, there's no guarantee. So it's like saying associates that bill 2,800 hours might get a bonus if the law firm happens to have a very good year.
But are there withholding? Is there a certain withholding as the year is going on towards that? Or is that just the I may be confusing what Mr.
Mechanically,
Lopez
how
said.
does it work during the year?
Yeah.
Well, actually, those facts are not part of the joint statement of facts, the specific workings of the branch manager program. So,
Well, there was some description about the stock is bought every 6 months, or
yeah, that's actually not in the joint statement of facts.
It's just in the briefs?
It's in one side's briefs, but we've resisted characterizing that because it's not fully part of the record.
Okay.
So,
Thank-
if I could,
You have
the other point I would just make.
quickly, yeah.
Okay, just one more point, which is that even assuming, first of all, we think the case law is clear, as I pointed out, that wages, that the restricted stock are not wages, whether they're in the financial consultant program or the bonus program. But even if they were to constitute wages, there's a whole nother provision of the Massachusetts general laws, which says that there's an exception from the Weekly Wage Act for deductions that are made for employee stock plans. So this is Chapter 154, Section 8. And we actually think the proper way to conceive of this is not really so much as a deduction for an employee stock plan. We think the better way to conceive of this program is that some form of the compensation is received in the form of restricted stock. So it's not that they receive their wages and then they deduct it. It's that part of their compensation is received in the form of restricted stock. So we think the first view is really the right way of viewing the program. But if the court were to view this as wages, even the restricted stock, then we would submit that the exception to the weekly wage law is for deductions made pursuant to employee stock purchase plans. So either way, the particular program here does not run afoul of the weekly wage law.
Thank you,
Thank you.
Ms. Vansel.